morning. This meeting is called back to order at 9:30 a.m. on Tuesday, November 14th, 2017. Welcome back to the Marble Mountain Ranch hearing. I'm Stephen Moore, Vice Chair of the State Water Board and Hearing Officer. With me, I'm being assisted by Staff Counsel Lily Weaver and staff Mmr Am and Jean McHugh, and other staff assisting me here. I want to thank everyone for returning, taking time out of your schedules to be here for the second day of this hearing. We know we've all made sacrifices to be here, and I want you to know how much we appreciate your time. At this time, just to remind folks, evacuation procedure before we get started. Identify the exits nearest you. The exit route over to my left, your right, is probably the best way to exit the building in case you hear an alarm. Please evacuate the room immediately. If you hear an alarm, we will gather at the entrance to the building out in the parking lot, and when we get the all clear, we'll all return to this room. We are broadcasting this hearing on the internet and recording both audio and video. In addition, a court reporter, Peter, is present to prepare a transcript of this proceeding. Anyone who would like an expedited copy of the transcript must make separate arrangements with the court reporter. And when you speak, please be sure to use the microphone so that everyone can hear you. At this time, let's all take a moment to check our cell phones and make sure they are muted. And we appreciate you double checking. So today, just to remind everyone, we're going to start with the cross-examination of the prosecution team's remaining witnesses. Then we will hear from Klamath Riverkeeper's opening statement and direct testimony, followed by cross-examination. After Klamath Riverkeeper, we will hear the Karuk tribe's opening statement and direct testimony of their remaining, witness, Leif Hillman. Following cross-examination of Mr. Hillman, Marble Mountain Ranch may proceed with the presentation of direct testimony of their remaining witnesses. Then we will continue in the order I outlined yesterday with the National Marine Fisheries Service, California Department of Fish and Wildlife, and remaining witnesses from the Karuk Tribe and Old Man River Trust. So are there any questions or other housekeeping items before we continue? Is that amenable? Yes, from the Karuk Tribe, Mr. Hunt, I believe.
Yeah, I would just like to say that we have flexibility. Maybe we got a little further yesterday than we thought we might. So if we're moving along and we don't need to fit Leaf in at the time allotted, and we can just do all of the Karuk presentation at once, that would be fine with us as well. Just so you know, if we're getting there, so we don't have to take things out of order depending on how it's going. I just wanted to bring that up in case.
Okay. Well, there's a lot of potential items stacked ahead of that, so I don't think at this time I could guarantee.
Sure. I just wanted to put that out there so that we can get back into the flow.
Okay. Well,
as it goes, but we'll see. Okay. Thanks.
We appreciate your the thoughtfulness of that offer. I think we'll keep the plan as we have it, though, just to keep us on track. Okay. Thank you. Would the prosecution team witnesses please come back up? You've already taken the oath, so we don't have to repeat that. But all the prosecution team witnesses, Mr. Filer, Mr. Anderson, Mr. Morano. And I want to invite Marble Mountain Ranch, Ms. Brenner, to prepare to conduct cross-examination.
So just another housekeeping question. I'm not sure how we're gonna, what the expectation of the board is on the panel cross, but what I propose is that there's certain questions that each of them could answer, or one of them can answer for the entire panel, and then have certain questions for particular witnesses, and they're direct. A lot of their testimony was the same, so, or repetitive, so.
that was my expectation, is it can be fairly open and, open-ended in terms of any witness you can ask a question of. It should relate to their specific testimony, as I would imagine that would be. So at this point, you can pick your own order of which witnesses to ask which questions.
Okay, thank you.
Yes.
If you're not sure, you might have a question for all the witnesses, not know who the best person to ask is, so you can ask the panel, and then they'll
Right.
nominate somebody.
Right. There's certain questions I have for particular witnesses, not the entire panel.
Right.
Okay. Good morning. I believe each of you testified that the Marble Mountain diversion impacts fishery habitat. Is that a true statement? Can I get an answer?
That's correct.
Okay.
Yes.
The reporter can't take your nods, so I need verbal responses. Thanks.
Absolutely.
What direct causal evidence supports that conclusion?
The data portrayed in my presentation yesterday supports the conclusion that there's been impacts to fisheries from the Marble Mountain Ranch diversion.
Are you specifically referring to the July 1st, 2009 data?
Yes.
How about the other data supplied by the Karuk tribe? Does that support your conclusion?
I'm going to object to that on the basis that it's vague. It would help if you would specify which data and which conclusions you're asking about.
I'm asking them what supports their conclusion. They indicated one data point in one set of a multiple-year of data. So I can get more specific on that particular set of data.
I think I would sustain the objection because you're asking about a different set of data and not about the testimony of the
He
panel.
testified to that data, his interpretation of the data, and he just indicated that's what he's relying upon.
Right, in his presentation, right, but
Right.
not the Karuk data.
No, he. Did you rely on the Karuk data for your testimony?
Karuk and U.S. Forest Service provided the data.
Okay, thank you for the clarification.
Okay.
I just want to make sure that we're asking about the testimony
Yeah.
that you received. Thank you.
Yeah, I'm actually using his data, or what he relied upon. And Mr. Anderson, you indicated that you followed up with the Karuk tribe relevant to the quote reported end quote fish kills, correct?
I believe it was alleged fish kills.
That was alleged fish kills.
Well, that's how I stated it in my presentation.
Did you obtain any follow-up evidence as to the cause of that alleged fish kill?
Yeah, we received information from Taz Soto with the Crook tribe, and which he indicated he believed the fish that was documented, I believe there was, from my recollection, there was 5 steelhead found dead in the Stanshaw Pool, and it was either 1 or 2 coho, and they believed that the fish died from temperature shock.
And do you know when that occurred, or is there any data, anything in the?
I would have to pull up the email to kind of give you further clarification. There's a lot of exhibits in this hearing, so I can't specifically remember all the details of that correspondence.
Do you recall if that was in 2009?
That sounds about right, but again, I can't be 100% confident without pulling up the exhibits.
So I'm going to object to that question. It's unclear whether you're asking whether the correspondence was in 2009 or whether the alleged you're asking about an alleged fish kill that would have occurred in 2009.
I'm asking about what additional information he obtained to support that conclusion. He indicated during his testimony that he sought additional information.
Well, and again, I would need to pull up the exhibit just to confirm, to be 100% confident it was 2009.
Okay. But you got it from the Karuk tribe?
Yes.
Okay.
So regarding the objection, I will overrule it. Continue the questioning, please.
Do you recall whether you were provided any temperature data during that time period as a result of that inquiry?
Yes, we were provided some temperature data and some flow data as well, or flow velocity data.
Do you recall what it said?
All of the data?
No, the data that supported the conclusion or the allegation of a fish kill.
No, if I remember the specific correspondence with Taz Soto, the data logger that was in that pool had been lost due to sedimentation, I believe, and that they didn't have specific temperature measurements when that fish kill was documented.
Okay. And I believe it was Mr. Anderson and Mr. Feller. And is that how you pronounce your last name? Filer. Thank you. That you both participated in an investigation at Marble Mountain Ranch.
Yes,
Yes, we did.
Okay. Did you observe outfalls from the Marble Mountain Ranch ditch?
Yes, we both observed 2 outfalls.
Do those outfalls help ensure no overtopping of the ditch?
potentially.
Do you know whether the Pelton wheel on the Marble Mountain Ranch can be adjusted to produce power with less than 2.5 CFS?
I'm aware that the Pelton wheel contains, as Doug described, different jets that can be inserted into the Pelton wheel. And now these jets have orifices of varying diameters that would then concentrate the flow of water to produce more pressure, which would drive the power production.
Okay. So you can adjust it such that if there's 2 CFS coming down the ditch, you can still produce power, correct?
Throughout our investigation, we never was able to get a threshold as far as the minimum amount of water in which Marble Mountain Ranch needs to run their Pelton wheel.
But you know it can be adjusted to produce energy at less than 3 CFS.
Yeah, and kind of for clarification, the capacity is stated in the original application submitted by the Youngs of the Pelton wheel, and the penstock, or excuse me, of the penstock is 2.5 CFS.
Is that the same Pelton wheel that exists there today?
I didn't say the Pelton wheel, the penstock.
Okay. Is that the same system that exists today?
I'm not 100% positive. I know the Pelton wheel has been changed out, but I believe the penstock has remained the same.
Okay. Do you know anything about the change out of the Pelton wheel?
No, I do not.
Okay. But you're aware it occurred by the Coles?
I don't know who, I'm unaware of the change out, so I don't know which party was in ownership when the change out occurred.
Okay. Are you aware of, we'll just ask it this way, was there a time period where the Marble Mountain Ranch was flood irrigated?
Yes, I believe that was indicated in either the Lanahan report or the Cascade Stream Solutions technical report.
And it's no longer flood irrigated today?
I do not believe so.
You testified it's now piped and use sprinklers?
Sprinklers and hose bibs,
Is that more efficient than flood irrigation?
most definitely.
Do you know how many people reside at the Mountain House?
Are you talking about Mountain Home, the landowners above?
Correct.
Well, Mountain Home, when the application was originally submitted, it was for, it was a large parcel. There were 5 homes on the land owned by, I believe there was Brickell. I would need to look at my inspection report to get exact last names of all the 5 families. But then one of the residents also had a rental, so there could be anywhere from, I would have to approximate 10 to 20 people on Mountain Home amongst the 7 different residences.
Where's that located?
Above Marble Mountain Ranch.
Is that how many people reside there today?
Where's there? Marble
Mountain
Mountain
Home?
Ranch or Mountain Home?
Mountain Home.
Well, my inspection, we learned that one of the landowners who occupied one of the homes had passed, and that his family had received it. They frequented it for vacation and holidays, and I believe one of the other residents was also more of a vacation in a second home of one of the landowners. But Mr. Steve Robinson lives there full-time. His son Noah and his family live there full-time, and they also have a rental with a tenant who lives there full-time and have some livestock.
Okay. That's your understanding.
But that's what we documented during the inspection.
In what year?
I believe that was in April of 2016.
Okay. In December 2015, had the stakeholders developed a physical solution for the Marble Mountain Ranch diversion?
No, there were a few options being discussed, but nothing was concrete.
Had the Coles voluntarily participated in the stakeholder process up until that time?
Yes,
Did the Coles consistently state that they would cooperate with the efforts to return flow back to Stanshaw Creek as long as such efforts allowed them to continue to function as a dude ranch?
yes,
Did the Coles consistently indicate that the cost to return the flow back to Stanshaw Creek was too high for them to absorb?
we've never seen any project proposals or quotes for
I
returning.
didn't ask you if you've ever seen any quotes. I asked you during the stakeholder process, did the Coles consistently indicate that the cost of doing return flow to Stanshaw Creek was too high for them to absorb?
I don't believe cost was indicated. It was physically. It was the physical nature of returning flows is what was cited as far as permits and other activities. Cost might have been included, but there was a host of
Issues?
hurdles.
Okay. When did NIMS provide their bypass flow recommendation?
Which one?
The last one that's at issue here today.
The most recent?
Yes, the most recent.
It was submitted to the Executive Director of the Division of Water Rights on August 3rd, 2016.
And when did the regional board issue their cleanup and abatement order?
That would be better suited for Stormer Filer.
I believe it was August 4th, 2016.
Directly after the NIMS bypass recommendation?
Yes.
Was there a physical solution in place at that time?
No.
Was there continued discussion, or was the stakeholders waiting for the NIMS bypass flow recommendation at that time as part of the process?
Not that I'm aware of.
Was grant funding available in May of 2016 for the Marble Mountain Ranch diversion? Some of the efforts to go towards the physical solution. In other words, was grant funding in place in May 2016 to help improve the Marble Mountain Ranch as directed by the regulatory agencies? Do you know?
Are you asking both of us still?
I'm asking any of you.
No, I believe it wasn't. There was a proposal, but the grant funding had not been, I think, considered by NIFWIT at the time.
Was Joey Howard working with grant money when he was developing some of the electrical analysis?
I'm not aware of that.
Did Joey Howard and Will Harling continue to try and respond to the regulatory agency requests in the spring of 2016 and summer of 2016?
Yes, they did.
Did they subsequently quit the project around the fall of 2016?
Can you elaborate on they?
Joey Howard and Will Harling.
I'm not fully aware of when they exactly, or either of them walked away from the projects. I know that they have, but I don't know the exact dates.
Did the Coles ever indicate to both the State Water Board and Regional Board that they had lost their consultant on this project around the fall of 2016?
I do recall the communication that the consultants did leave. I recall the dates.
Okay. Do you recall a report from Mr. Fiore Geosciences report that was submitted to both the State Water Board and the Regional Board regarding the Marble Mountain Ranch diversion?
Yes,
Was that in response to the cleanup and abatement order? Was that report prepared in response to the cleanup and abatement order?
yes.
Do you recall the conclusion of that assessment?
I'd need to look at the report. There were several conclusions in the report.
Did Mr. Fiore find that the ditch deposition areas you photographed have been stabilized over the years?
No,
That's not your recollection of the report?
no, he said he didn't think they were an ongoing problem, but he didn't see that they were stabilized.
Did he think that it was a good idea to fill those deposition areas as recommended by the regional board?
The regional board's recommendation was not to fill those areas. The regional board's recommendation was to provide restoration measures for those areas where they were affecting streams.
Did he agree with that assessment? Did he agree with that recommendation?
No,
Did you actually see sediment from Marble Mountain Ranch ditch enter Stanshaw Creek during your investigation?
I saw evidence of
Are we
erosion.
coaching our witnesses over here?
I saw evidence of erosion.
Okay. So your answer is no?
Now, you could see water from the second outfall, if you recall Stormer's presentation, and the proximity to Stanshaw Creek in the background. There was a pretty good amount of flow, about, say, a third to half of a CFS going down the hill, which was carrying I'd describe it kind of as storm water. It was muddy, murky water you could see entering Stanshaw Creek.
And where was that water coming from?
Secondary outfall structure, approximately 300 feet downstream of the POD on the Marble Mountain Ditch.
Is that the area where the trestle used to be along the ditch?
I'm unaware of a trestle.
Okay. Does the Marble Mountain Ranch ditch experience debris flow? Do you know?
Can you clarify your question?
Does it experience sediment and small pebbles from the Stanshaw Creek into the ditch? Does sediment flow from the creek into the ditch?
Yes.
Is Stanshaw Creek a steep slope creek system?
Yes, I'd consider it pretty vertical.
Did you walk Stanshaw Creek? Did you investigate the creek itself?
Yes.
Did you see any slough off along the creek bed or along the creek banks?
But can you be more specific?
Can you answer with a verbal response for me?
Can you be more specific to your question, please?
Did you see any sediment deposition from the bed or banks of the creek itself into the creek during your investigation?
I did not walk the stream of Stanshaw Creek during my inspection.
Okay, I'm sorry. I thought you just indicated that you did.
That wasn't during the inspection. That was when we went back to install pressure transducers and data loggers in the stream in 2017, we had to walk the stream because we were not granted access by Mr. Cole to use his property.
Correct.
So we parked it.
So that, okay.
Yeah.
So did you see slough off along the creek system when you walked it?
I wasn't particularly looking at
Okay.
slough off on,
But it's a steep creek system, correct?
yes.
And it experiences some significantly high flows in the wintertime? And by significantly high, in excess of 30, 50 CFS?
I don't believe 50. When I've looked at the surrogate data that Margaret Towser had procured from the T Creek gauge, and when you average the 4 years from 61 to 64, I believe the highest flows I saw were in the upper 30s.
That's an average high. I'm asking for not an average, but an actual,
Again,
you don't know?
I didn't see any days where it was above 30 CFS or into the 40s.
Have you experienced other steep slope creek systems in Northern California?
Yes.
And
As
yes,
when you've inspected those other creek systems, do you often see sediment flowing down after winter rains?
there's a lot of variables that would contribute to sediment entering a stream after winter rains.
Would you consider Stanshaw Creek a sediment transport system? In other words, does it typically transport sediment during the winter rains?
All streams transport sediment during winter rains.
And your time of inspection, did you witness any ditch overtopping?
No.
Are you aware of the last incident of any ditch overtopping? Any anecdotal evidence?
I could see areas where the erosion had been caused over the ditch berm through ditch overtopping or ditch bank failure, berm failure.
And did Mr. Fiore examine those deposition points as well?
To the best of my knowledge.
Other anecdotal evidence would be the 2014 report by Mid-Klamath Watershed Council that contributed the sedimentation of the Stanshaw Creek Pool to a catastrophic failure of the Marble Mountain Ditch.
Is that the restoration project from
Yes,
the report?
yes.
Do you recall what year that was alleged? The overtopping was alleged in that report?
If you pulled up the report, we could further confirm and nail down the exact year.
Did you see anything in that report that showed direct evidence that the overtopping caused the sediment? Overtopping of the ditch caused the sediment in the pool?
No.
Did either of you calculate any sediment budget on the ditch system, the Marble Mountain ditch system?
No.
Did you calculate any sediment budget on Stanshaw Creek?
No.
Do you know how many miles Stanshaw Creek is?
I know the square mileage of the watershed, but as far as like the length of the stream as like a crow flies, no.
Okay. Do you know what I mean when I say a stream system is diurnal? It's a diurnal stream system?
Yes.
Can you tell me what that means?
Means it's going to have, it behaves differently from night to day.
Behaves differently in what way?
There could be fluctuations.
In flow?
Yes.
Is Stanshaw Creek a diurnal system?
I don't believe that's in my testimony, nor am I an expert at classifying stream systems.
Okay. I'm sorry, Filer?
Yes.
Thank you. Can we go back to your testimony about July 1st, 2009? Do you recall that testimony?
Yes.
And you produced a graph regarding the flows from that date, correct?
No,
No? You didn't use this table or graph or, I don't, what do you
yes,
want?
I did, but that's not flows.
What is that?
Temperature.
That's temperature, correct. Thank you. But you did produce this as part of your testimony regarding temperature on July 1st, 2009.
Yes,
Okay. And where did you derive this data?
from the Carrick and U.S. Forest Service data that I was provided.
And do you know the methodology they utilized to collect that temperature data?
I believe the temperature data was collected with a data sonde placed in the Stanshaw Creek pool.
Do you know where in the pool it was placed?
No, I do not. Toss Soto is here today, though, and he could perhaps clarify that for you.
Yeah, I just want to talk about your interpretation of that data. Did you look at the days preceding the July 1st, 2009 temperature data?
Yes, I looked at a lot of data.
And what did the days prior indicate as with regard to the temperature of the pond?
The days prior indicated that it looked like there was still water going in the pool. There wasn't any air temperature readings on the data sonde.
What do you mean by air temperature data?
So the elevated temperature you see on that graph indicates more than likely the pool went dry or the data sonde was exposed to the air.
So on July 1st, something occurred to expose the data logger to the air temperature, correct?
It appears that on July 1st, flows dropped low enough to where the data sonde was exposed to air temperatures, or the pool was completely dried up, depending on where the
Do
data
you know
sonde was
where the
placed.
data logger was placed in the pond?
I'm going to refer you to Todd Soto again. as
I
he's the
just want to
person
know
that-
what you know.
I don't know, no.
But it's your testimony that so are you stating that the air temperature went to 106 or the pond temperature went to 106 on July 1st, 2009?
The data sonde read a temperature of about 107 degrees Fahrenheit on that day.
Would that likely be the temperature of the pond on that day?
Evidently, if the data sonde was placed in the pond, yes, it would be the temperature of the pond on that day.
So it's your testimony that the pond temperature went from 63 degrees to 106.9 degrees in a matter of an hour?
That's what the data showed.
Okay. Do you have any indication of what could have caused the decrease in pond level, such to expose the data logger?
As I stated in my presentation, the flows on that day were measured, and it showed that the diversion was active, and there was 0.5 CFS below the Highway 96 bridge in Stanshaw Creek, and I believe it was 1.8 CFS in the diversion outfall before it enters the tributary to Irving Creek.
Was that the same case the day before?
I would have to look at the data. The data's not consistently measured every day for flow, so I can't testify to that without looking at the data.
So you're assuming that the diversion caused this decrease in flow?
It was evident that the diversion was active and the temperature change happened.
That was
That's
just-
one possible cause of that happening.
That's one possible cause.
I'm having trouble thinking of any others, to be honest.
Are you aware that there's rocks piled along the pond area at times to keep the water in the pond?
No,
You're not aware of that?
no, not along the pond area, no.
Are you aware of berms diverting water into the pond? Rock berms diverting water into the pond?
I saw images yesterday of rock berms diverting water into the pond, yes.
But you weren't there in July 1st, 2009 to observe anything directly, were you?
No,
Somebody could have removed rock berms and released water from the pond And that would lower the level of the pond level, or the water level, correct?
I am not aware of any rock berms on the pond that would be removed by somebody manually or,
That would also be dependent on the level of the Klamath River, if water is going to flow in or out when you remove rocks.
What's the flow of the Klamath River usually in July?
Not 100% sure. Changes every year, as we heard yesterday.
The data from 2009 that you reviewed indicates that the temperature decreased within hours, correct?
over about 9 hours.
It consistently decreased from that temperature, suggesting that the pond level, if your assumption is correct, went back up.
After about 4 or 5 hours, it looked like there might have been water going back in the pond based on the temperature data.
So if it was caused by the Marble Mountain diversion, they would have had to increase and then decrease their diversion at that within those few hours.
I don't honestly know what happened, but I do know the data shows that happening.
Yeah. Do you know the lethal temperature for fish, water temperature for fish?
We're going to object to the specificity of that question. Perhaps you could more specifically identify the type of fish temperature, lethal temperatures you're asking about.
Sustained.
Is 107 degrees water temperature lethal for fish?
Yes.
Are you aware of the ambient temperature on July 1st, 2009 at the Marble Mountain Ranch, at the Stanshaw Pool area?
Not specifically for that day, no.
And the days prior to the July 1st, 2009, did you look at the data for those dates as well?
Yes.
Was the pond temperature during those previous days pretty consistent?
Relatively, there is some fluctuation.
How about the dates after July 1, 2009?
The data record for that year ends shortly after July 1, 2009.
There was no more data collected after July 2nd, 2009?
I would need to look at my data records to answer that question.
Did you produce the full set of data that you were provided as part of your exhibits for this hearing from the Karuk tribe?
Yes, I believe so.
Okay. You're not aware of any other temperature or volume, velocity data for 2009 in August, for instance?
No, I looked and I couldn't find any.
Okay.
Well, let me clarify that. I'm not aware of any temperature data for 2009 in August. I'm aware of flow data for that period, though.
Okay. Are you aware of any fish data during 2009 in the Stanshaw Creek Pond?
I'm aware of the emails regarding the fish kill that Mr. Anderson mentioned earlier.
Is that the fish kill that the Karuk tribe has documented as occurring in 2009, July 2009?
Yes.
And are you aware that at that same time, that there was an excess of 100 fish in the Stanshaw Creek Pond?
No.
Are you aware that Mr. Fiore evaluated the ditch stream crossing of the unnamed tributary at Stanshaw Creek? That he inspected that particular fallout?
Yes, and NOV number 3 provides a response to Mr. Fiore's report for the record that from the Regional Water Board that is quite in depth in terms of our disagreements and our agreements.
That's fair. You definitely disagree.
I can pull up the NOV if you'd like and show you specifically what the Regional Board decided to state about that issue.
No, I'm interested in the engineering geologist report and what you know about what their full evaluation of the system. Do you know how many days Mr. Fiore was spent at the Marble Mountain Ranch inspecting his diversion system?
I need to look at his report.
Okay. Can I have just 1 minute?
Yes, yes, you take a minute. Please stop the timekeeping.
Mr. Vice Chair, while we're taking this brief break, I've been informed that one of my witnesses requires a natural break.
Let's take 5 minutes, and we'll resume the hearing at 17 after. Okay, are we ready to reconvene? And thank you. I wanted to offer a couple of suggestions just to improve the transcript and the flow of and the understandability of the discussion. So we want to do our best to identify, which person you're asking, just for the record, so that when we look at the transcript, we have a good sense of which person has responded. And also, during the questioning, there were some references to some exhibits, and if we could do our best to identify exhibits as we've enumerated them in preparation for the hearing, it would be very helpful. And then we can even bring it up on the screen if you're talking about specific language. So just some suggestions to improve the hearing. Anything else?
So,
This makes it much easier for us when we go to write the order, so we
Right.
appreciate it.
and so we can identify the Fiore Geosciences report that was submitted as part of Marble Mountain Ranch's exhibits, and then the Karuk tribe data, I believe, that was submitted by the Karuk tribe, and we can identify that particular exhibit. Carrie, do you have those exhibit references handy? The temperature data that Mr. Filer was relying upon from the Karuk tribe? Of the prosecution team, and the Fiore Geoscience report is Marble Mountain Ranch. What exhibit number? Thank you. I have no further questions.
Okay.
So just to confirm with the microphones, the graph was PT 190? 191?
PT 191.
Um,
Sorry,
WR.
WR.
Yeah, that's right.
Yep.
And then the
that's not-
exhibit,
To clarify, that's only the graph, not the actual data.
right, but the specific graph that Ms. Brenner held up and asked questions that held up, that was PT 191.
Correct.
Okay.
And do you know the data? That's 190. So this data set is 190.
WR 1.
WR 190.
Thank you.
That's, yeah. Right, the Fiore report is MMR 12.
Thank you.
Great. And so that concludes the cross-examination?
Correct.
Okay. Thank you. So at this time, I would offer up a cross-examination of the...
Hold on, we're going to get you exhibit number for the notice of violation number 3 from the Regional Water Board, which was also brought up.
And while we're waiting for that, the next opportunity for cross-examination is from National Marine Fisheries Service. No questions? California Department of Fish and Wildlife. Can you please approach? And let's get the name tag and now the identification of the exhibits.
NOV number 3 is WR 167.
Oh, that was the first one.
All right, thank you for that administrative task. And Mr. Pacini?
Thank you. This is to the panel. Is there anything in the NIMS flow recommendation that was not raised or discussed in some fashion during various stakeholder meetings with the Coles or the consultants, to your knowledge?
No.
That was Mr.
Actually-
Anderson.
Yes, and actually, the original recommendation from NIMS was augmented to the Coles request. And so NIMS went back and reconfigured their recommendation to something that the Coles requested and was more conducive for their diversion operations.
When was that request made approximately?
I believe that request was at the second stakeholder meeting that occurred in January 2016.
So at least at that time, the Coles or their consultants were familiar with the flow recommendation as it stood at that time.
Yes.
Is there anything in your NOVs, CAO, or the draft order that was not previously raised or discussed with Mr. Kohler's consultants prior to issuance?
Prior to issuance of the draft order, the Coles had received a report of inspection which outlined the same corrective actions that were documented in the draft order.
Is it fair to say that Mr. Kohler, Marble Mountain Ranch, should not be surprised in terms of the recommendations or contents of any of the documents I just described?
No, and to add, the 2002 inspection by the Division of Water Rights contained about, I would say, 80 to 90% of the same corrective actions that the 2015 report of inspection contained.
Is it true that the State Water Board issued a total of 3 notices of violation against the Coles and Marble Mountain Ranch?
The North Coast Regional Board issued 3 notice of violations in regards to cleanup and abatement order.
Is it true that the first NOV was issued on December 3rd, 2015, following inspections in December 2014 and February 2015?
I believe so.
Is it true that the CAO and draft order was issued in August 2016?
That is correct.
No further questions.
Thank you. Next, offer the opportunity to cross-examine to Karuk tribe.
Good morning. There was a series of questions related to possible causes of the temperature changes in the pond, and I'm curious whether you all are aware of when the enhancement work in the pond area first began.
By enhancement, do you mean the restoration project that was conducted by Mid-Klamath Watershed Council, or?
Yes.
I believe that was conducted in 2013. For an exact date, I would need to reference the exhibit.
You mean it was conducted or it began?
Again, I would need to reference the port. From my understanding, it was completed, I guess, let's say in 2013. When it began, I'm unsure.
And do you know if there's continued efforts since then to maintain it?
To be clear, I haven't been in correspondence with anyone regarding what the continued efforts are to maintain it.
Okay. Thank you, that's all.
Thank you. Next for cross-examination is Old Man River Trust. Mr. Fisher.
The calculations you all stated to determine consumptive water use at Marble Mountain Ranch, was that a standard practice of, a standard calculation used by the State Water Board? I don't need the exact number. I just wanted, like, in general, is that how the State Water Board determines how much water is reasonable?
Are you referring to the refined calculation?
Yes, of consumptive water use.
Yes, I was in correspondence with Joey Howard and Will Harling. They had asked for some direction. I directed them to the California Code of Regulations, Title 23, Section 297, which has identified uses for different irrigation types and stock watering, things of that manner.
Great. And had anyone done that before, to your knowledge?
I don't believe so.
Thank you.
Okay, thank you. Next, Klamath River Keeper, have any questions for the prosecution team witnesses? Thank you. California Sport Fishing Protection Alliance? No questions. Thank you. Pacific Coast Federation of Fishermen's Associations? No. And at this time, does the prosecution team have any redirect questioning?
Yes.
Okay. Please approach the bench over there. Not this bench, that bench.
So, Mr. Filer, since this is a water right, hearing, can you maybe talk about just what a cleanup and abatement order is, what it seeks to achieve, and why a regional board would issue a cleanup and abatement order?
I'm going to object. This goes beyond the scope of my cross-examination.
Ms. Brenner asked numerous questions about, the cleanup and abatement order, when it was issued, why it was issued, and, since this is a water right hearing and a cleanup and abatement order is not something, we're used to seeing, I believe this is a relevant question to inform the people here just what a cleanup and abatement order is, why a regional board issues one, and what a cleanup and abatement order seeks to do.
Could you repeat the question?
Thank you. Mr. Filer, can you describe what a cleanup and abatement order is, what a cleanup and abatement order seeks to achieve, and why a regional board would issue a cleanup and abatement order?
Again, I'm going to object. It goes beyond the scope of my cross-examination. My questions were very narrow as to time of issuance, just to set a timeline of events.
I'll sustain the objection.
Mr. Anderson, during the investigation, did you attempt to find out what the operating threshold of the Pelton wheel was?
Yes, I corresponded with Joey Howard, and he also was unaware of what the minimum operating threshold was of the Pelton wheel.
So you never really got a good answer to that,
No, I did not.
but you tried to get one.
Yes, we did.
Okay. Mr. Filer, when the regional board issues a cleanup and abatement order, is a physical solution normally required before the regional board would issue such an order?
No, the order is issued to get at a physical solution, finding the best alternatives to fix something, to find that's a problem or a violation, basically, of the water code.
And does a cleanup and abatement order include findings identifying failures and overtoppings of the ditch?
Yes.
Okay. And is that a final order?
Yes.
This question could be for either Mr. Anderson or probably Mr. Morano. Do you recall meetings or conference calls prior to the issuance of the August 3rd, 2016 flow recommendation from NIMS discussing the flow recommendation?
Yeah, I believe, yes. We met with the Coles and their legal counsel, NIMS, and representatives from the Mid-Klamath Watershed Council, the diverters engineers on May 13th to discuss the proposed in-stream flow recommendation that we received from the National Marine Fisheries Service.
And do you recall the extent that that it was discussed with them?
We discussed how Marble Mountain Ranch's diversions would be affected by the recommendation when non-consumptive diversions, or excuse me, diversions for just consumptive uses are occurring, when diversions for consumptive and non-consumptive uses are occurring in all seasons of the year.
So before the recommendation was issued, there was discussion of it with the Coles or with their consultants or legal counsel.
Yes, multiple discussions on 2 different flow recommendations.
Mr. Filer, do you recall when the draft cleanup and abatement order came out?
December 3rd, 2015.
Okay. And do you recall how the final order may have differed from that draft?
I don't think it differed except for changes in dates or setting dates for compliance deadlines, directives, to meet directives.
No, no further questions for them.
Okay, thank you. And at this time, offer the opportunity for any recross examination to Marble Mountain Ranch. Sure.
Mr. Anderson, you testified that in May of 2016, there was a stakeholder meeting amongst the Stanshaw Creek group.
Yes,
And did you attend that meeting?
yes, that meeting was in the Division of Water Rights, the Cal EPA.
Was that the Cal EPA?
Yes.
Was Mr. Harling in attendance at that meeting?
No, I believe they called in.
Okay. Had the bypass flow recommendation been issued at that point?
No, it had not, but it had been the changes that were requested by the diverters had been incorporated into NIMS's in-stream flow recommendation, and it was in draft form at that time. But that was the recommendation that NIMS was moving forward with on getting signed and approved.
Was there any indication by the Coles at that time that they wouldn't be able to comply with that bypass?
There was indication that the Coles were unaware of the full ramifications of the NIMS flow recommendation.
Okay. I'm sorry, Taro, I cannot see your last name. Is it Mr. Morano?
Correct.
Thank you. Do you recall in your testimony that following the January 14, 2000 meeting in Orleans, the division requested technical assistance from NIMS and DFW to develop bypass flow recommendations?
That's correct.
Okay. This was something that was in flux. Is that safe to say?
Can you explain
It was changed. It was dynamic at that time. There's nothing set in stone as to what
the cooperation or
the bypass flow recommendation.
it was being considered by NIMS.
Okay. I have nothing further.
Okay, thank you. Any other recross examination from the different parties? That would be National Marine Fisheries, Fish and Wildlife, Karuk Tribe, Old Man River Trust, Klamath River Keeper, Sport Fishing Alliance, BCFFA. All right, thank you. So now that we've completed this phase, I request that, or is there any staff questions? Or- Okay. Well, we'd like to take 5 minutes to confer among the hearing team staff, and we'll return at 10:42. Okay. Thanks, everyone. We have a couple of questions we'd like to ask the witnesses. And are we going to start?
So I have a question for Mr. Filer. Do you recall a line of questioning during cross about lethal temperatures to fish?
Yes,
What kinds of fish communities were you talking about in your answer?
salmonids.
Salmonids. Okay. Any
So-
geographic information or just salmonids?
Salmonids, essentially, if you have a 40-degree temperature increase in a pool, you're going to see mortality of pretty much everything in there.
Thank you. And then I have a question about some of the photographs that were used in the slideshow presentation for Mr. Petrozelli's opening statement. If we could pull that up. It'll be page 9. So we haven't been able to identify where in the record this photograph came from.
That photograph was an attachment in an email received from Taz Soto. I believe it was February 12th, 2015. I could have kind of looked through the exhibit list to give you guys exact exhibit number if that would be helpful. But I do know that the email was received in February 2015.
Okay.
And
So this.
I believe that those photos are also included in the water right investigation report.
Okay, we can check that. So this is a photograph that was sent to water rights enforcement staff by the Karuk tribe.
That is correct.
Do you happen to know who took this picture?
No, I do not.
Anyone else on the panel?
I believe it was Taz Soto, but I'm not sure.
Okay, and that's based on him having sent the email or something more specific?
Conversations with him that he told me he documented that fish kill.
Okay, and do you know who, I mean, I'm an attorney, so fish all kind of look the same to me. I should let you talk, though.
I was just going to reference as to why we believe it was Taz Soto. There's another photo that he included in his email that shows him present during the same time when this fish was pictured.
Okay, thank you. Who identified this fish as a coho salmon?
I believe it was Taz Soto.
Okay, so none of you, other than someone reporting to water rights staff that this is in fact a coho salmon, have any of you independently confirmed that, applying your knowledge as environmental scientists?
Yes, I've relied on other individuals in the Division of Water Rights to help educate me on identifying fish species. Those individuals work in the Public Trust Unit, and the salmonids, such as the coho here, have par marks on them, which are an indication, which can be used as an indication of the type of species. The par marks are those oval, darker coloration, almost kind of look like stripes on the fish.
Okay, are there other fish species in this kind of Northern California freshwater ecosystem that could have these kinds of markings that we can see in the photograph, or would that be unique to salmonids or to coho specifically?
These specific par marks and are specific to coho salmon.
Okay, and that's based on your,
That's based on using, NOAA had a chart that I found online that showed steelhead, coho, and Chinook salmon, all of which I think are the salmonas that you're going to find in this stretch of the Klamath River. And looking at that diagram and comparing the diagram to the fish, and also relying on other more fishery educated staff in the division, they confirmed it was a coho salmon.
The red fins are also a good indicator it's a coho. You can see the red fins in the image.
okay, and to the extent that the panel has testified about things they were told by other division staff who aren't here and haven't taken the oath, I'll simply note that's hearsay. I want to make sure we're being fair and giving folks a chance to object.
We did file objections as part of our, some of the briefing that we did prior to the hearing, objecting to the numerous amount of hearsay evidence that's being relied upon in this hearing. And we continue to object that the hearsay evidence should not be used as direct evidence against the Coles and Marble Mountain Ranch.
I have no further questions for the panel.
Could we please bring up slide 3 of Skylar Anderson's PowerPoint presentation? Thank you. This is a question for Skylar. Could you please explain, using this diagram, where the flow measurements were taken? There were 3 that were described.
So the first flow measurement was approximately 50 feet downstream of the point of diversion, just below the outfall structure, the first outfall structure. The second location was in between the penstock. Oh, here, I'll make this easy. So you're approximately here.
So that was 1, and 2
Yeah.
was right above
So
the pencil.
we'll
Yeah,
let the-
I'll go in order.
We'll let the record show that he's pointing to the red line,
Okay, so
which is the diversion ditch.
yeah, at this location in the diversion ditch, approximately this location in the diversion ditch, approximately this location in the diversion ditch.
So when you described calculating conveyance loss, are you considering the water that was consumptively used by the water treatment facility?
Yes, I'd also like to kind of further clarify that the locations that we used were locations in which there has been structures installed that are of uniform shape of the channel. They're steel boxes. So these sites were used because having a uniform bottom and also laminar top section is a preferable location to take flow measurements. And kind of getting back at your question, the inspection was done during February, which is the slow season for the Coles. Diversions to the water treatment facility are very passive. If I get this correct, the Coles use what they refer to as a Schmush-Decky treatment facility, which is, if I understand, that translates to slow sand filtration. So water is diverted and passively will stay in the pipe, go into the diversion tanks, filter through the sand, and as it's filtered and purified, it then flows to other holding tanks that are then used for the drinking water, and I think for some irrigation of some organic vegetables. So it's not like there was a constant rate of diversion of 2C or of whatever the velocity would be for the gravity-fed diversion in a 2-inch PVC pipe. So
Okay.
for example, if the tanks were full and the bottom tank's holding the purified water, there would be no diversion coming through. So as they use water, it's going to create more space, and more is going to slowly would filter through the sand, add to the tanks.
So at the time of your inspection, you felt that there was not a large amount of flow going to the water treatment facility?
Yes, and I also felt that taking stream velocity measurements in the engineered locations would have gave a more accurate flow velocity measurement than taking them in the channel that's going to have other variables such as, the bottom's not going to be consistent, and there could be other anomalies such as stones or just uneven variations in the channel will lead to less accurate depths, less accurate velocity measurements.
Right. I'm concerned only about the calculation of conveyance loss, and it sounds like you feel confident that subtracting 0.1 from 0.2 at the time of inspection would accurately assess conveyance loss.
Can you clarify by 0.1 to 0.2?
The flow measurement taken near the POD from the...
I believe the flow measurement, if my recollection is correct, it was 2.23 at the first location. It was 1.63 at the second location. That was for conveyance loss of 0.6. The application file also indicates numerous inspections in which other division staff went out and conducted stream flows, and they documented the same conveyance losses. Actually, to be fair, theirs was 0.5. I'd also like to add that the application submitted by the Youngs identified that there was a known conveyance loss of 0.5 from the POD. Further, that's why 3 CFS is required, and as noted earlier, the penstock has a capacity of 2.5. So the need for diverting 3 is because the loss is known and is well documented in the file.
Okay.
At different times of year, the loss could be different, could fluctuate.
Thank you. I have one question for Mr. Filer. In your written testimony, you described that your inspection was incomplete. Could you explain in what way?
Can you reference where I've stated that in my testimony, please?
Yes. It was number 25 on page 8.
Yes, I can clarify that. So I'm there for a limited amount of time in one day doing an inspection, and basically as a regional board staff looking for compliance with the Port Cologne Water Quality Control Act. We regulate the discharges of waste. So what I'm doing is I'm looking at the diversion works and the ranch, and I'm looking for places where waste can be getting into waters. And so as you progress through your inspection, basically I start out, I walk the ditch, and I look at it and I say, okay, there's some problems here, here, and here. And then as I return from on the ditch, I identify and document each one of those spots. But it's only a limited, in terms of, it's not exhaustive, is I did not walk over the entire ranch, nor did I walk up and down Stanshaw Creek on that day, because of time limitations for travel and inspection.
Did you observe the entire ditch?
So it's not physically possible really to walk the penstock, but I've looked at most of the rest of the ditch, yes.
Okay, thank you.
Go ahead.
Michael Buckman. I have a question for Mr. Morano. On page 12 of 16 of the PDF of your testimony, which is WR7, you cite to an exhibit, prosecution team exhibit WR 200. Can you please clarify what exhibit you're talking about? It appears from review of it, it might be WR 193 because there is no WR 200.
We initially had that exhibit numbered as 200, and it was later renumbered to 193.
So we have one more question. So you showed us on the screen where the measurement points were. It's a bit of a challenge for our court reporter to write that down. So we wanted you to, we've made a map based on the slide. We wanted you to confirm whether or not this represents the points you showed us. And so let me bring it down to you.
Well, I don't know if it'd help, but in my slideshow, I had a satellite image that showed the locations of where stream velocity was taken. And it also has text boxes which show the measurements. If you pull up my presentation and just maybe zoom out so you can see all the slides. Just actually, I could probably go through my testimony, provide you the slide number.
It's slide 17, it looks like. So I mean, that's the actual, it looks like aerial or satellite imagery, but
yeah, if you prefer to come down with the map, whatever's
Yeah.
easiest. Yeah, this is a fair approximation of the locations of stream velocity measurements.
Well, thank you for that. That's in the name of clarity. And
so just to be clear, to the best of your recollection, those are the points you indicated in response to Ms. Irby's question.
Yes.
I just want to take a look at it and
Absolutely.
indicate, can we get a copy of it?
So I'm going to propose that this be entered as a staff exhibit, and then everyone will be able to refer to it. And then I just note that this is indicating the points that Mr. Anderson showed us in response to our questions.
Correct.
yes, you, okay.
And the prosecution team would also like to state that the diagram was intended for demonstrative purposes and it's not drawn to a precise scale. So,
Understood.
Yeah.
It's a schematic in nature.
Mr. Anderson, are you able to confirm, since you've taken the oath, that the schematic is not to scale, it's demonstrative?
Yes.
No objection to your counsel's characterization? Okay.
All right, very good. Anything further from staff? No? Okay. So at this time, I would like to request the prosecution team offer exhibits into evidence.
at this time, the
any.
prosecution team does offer its exhibits and case into evidence.
And do the parties have any objections? And, okay, so, oh yes, please.
I'll just continue to reiterate my objections as to hearsay evidence and any evidence referencing pre-14 water rights or any challenge to the pre-14 water rights.
Okay, so noted. We have addressed those issues in our ruling letter, October 31st. Okay, so the exhibits are entered into the record. And thank you to the witnesses, and we are now completed with this part of the hearing. And you're free to go. And we'll now hear Klamath Riverkeeper's opening statement and direct testimony, followed by cross-examination in the order I've previously identified. Redirect and recross-examination of the witnesses may then be permitted. Counselor?
Before we get started, I just want to note that I'm not sure how to handle this testimony. There is no testimony. So perhaps this is a policy statement, but without any witness testimony submitted, no witnesses. My understanding is you're not going to call any witnesses today, correct?
We're going to be making an opening statement to clarify and identify the main concerns of Klamath Riverkeeper in connection with this hearing and to highlight those aspects of the written and oral evidence that's been submitted that we believe authorize the Water Board to curtail the diversions.
The written and testimony of who?
Of all the parties.
Okay, so this doesn't provide an opportunity for me to cross-examine anybody with regard to the allegations or argument that's being made. And again, I'd suggest perhaps this is a policy statement, but it can't be accepted as anything other than that.
It would be helpful if you could clarify this. Are you planning to present argument, or are you proposing to testify as to matters of fact?
We're not proposing to present argument, but we are proposing to do an opening statement that clarifies and highlights the concerns of Klamath Riverkeeper as it relates to the matters of this hearing, in the same way that attorneys representing the prosecution team or representing the Marble Mountain Ranch have presented opening statements, and I don't think there was any objection to those being provided.
And as indicated at the beginning of the hearing yesterday, the opening statements is to set forth so that you can provide an opportunity of what's going to be presented as evidence, not just an open statement. So again, if we want to make a policy statement, that's one thing. But if you're going to say that you're getting an opening statement, then you usually rely on particular evidence that allows someone like the Coles to cross-examine. Otherwise, you have a very one-sided statement. Quite prejudicial, I might add.
Well, we've indicated that there will be opportunity for cross-examination. Okay. All right.
Give us 1 second.
I will add that I'm certainly available to answer any questions relating to the opening statement, that it's not a general policy statement. It's specific to the matters and evidence for this hearing.
Okay. We're going to confer on the matter. Thank you for bringing it to our attention.
If possible, I would appreciate the opportunity to make 2 comments, but I can wait till after if that's appropriate.
So this has created some confusion. And so we want to be clear or give you the opportunity to make an opening statement. But anything things that are subject to cross, you need to be able, you have to take the oath and then be ready to take questioning. So I'm uncomfortable because we're conflating a couple of roles here. And so I'm going to ask legal counsel to explain your choices at this point.
Sure. So there, and this is something that we've kind of been wondering about too, and we're glad to have the opportunity to resolve it. You have the option of either presenting a policy statement, which would just be argument. If you wanted to submit testimony or move exhibits into the record, you would need to take the oath, you would need to give some foundation for your exhibits, and then you would be subject to cross-examination by the parties. If you just want to give a policy statement, that's one of your choices, but then you wouldn't be able to introduce your other exhibits because you'd have no one testifying to substantiate them. And we need to give all the parties opportunity for cross on factual matters.
Okay, thank you. The only exhibit that I will be presenting is the PowerPoint slides, which I've already given a copy of, so there's going to be no other introduction of exhibits beyond that. But I would like to make myself available to answer any questions, so I am prepared to take the oath and do that as a witness, if that would enable that. And 2 other just quick comments I just wanted to pass along, and I appreciate your thoughtfulness in approaching the situation. The first is that this issue was first brought to my attention, this objection, about 10 minutes ago. And it seems to me that it was evident that we didn't have any witnesses that were being called. That's been known for some time. I do feel that raising it on such short notice by Marble Mountain Ranch I have some questions about that in terms of timing. But also, when it was discussed with me orally, the objection was that it was going to be legal argument. And it seems to me that if the objection is, I'm a lawyer, and therefore I can't make an opening statement, but if I happen to be the executive director of Klamath Riverkeeper, it's fine. That doesn't seem appropriate.
So I don't see anything about you being an attorney that would disqualify you from testifying as a witness if that's what makes sense between you and your client. It's just a matter of, we have 2 clear paths. Yeah. Either you give legal arguments or you give testimony under oath and are cross-examined. And, we can't go up the middle.
Mm-hmm. So I'm happy to go with the second. If I could have just a minute to confer with my client, but I think the second option sounds better.
Okay, and if we could just scroll down to the MMR, I don't mean MMR, I mean Klamath Riverkeeper. Too many K's and R's. You had submitted other documents. I mean, it looks like we numbered these as exhibits and posted them.
Yes. Prior to the hearing.
So if you want these to be evidence in the record, then you would need to put on a witness who can authenticate them and provide foundation for them, and then that witness would be subject to cross-examination. If you don't want these to be in the record or you're indifferent, then you wouldn't need to put on a witness. But we'd have to strike these, I think, if there isn't someone testifying for them.
Okay. May I consult with my...
Absolutely.
Okay.
I'd just like to raise a couple points. The idea is that there would be written testimony submitted ahead of time so that we have an opportunity to see what that testimony is, and then it's a summary here. I'm not aware of a PowerPoint being submitted as an exhibit. all I recall is basically a legal brief, what amounts to a legal brief being submitted. So I was confused. I wasn't sure what was going on. Assumed it was just something along the lines of a policy statement. So again, it's very unfair and prejudicial against Marble Mountain to allow all of a sudden a witness to come up that has never been identified, and we don't have any written testimony submitted. So I'm going to object and indicate that that is quite prejudicial and should not be allowed.
Okay, we're going to take that under consideration right now.
Yeah.
Hold on.
Can I make, sorry, just one clarification?
Just not yet, please.
Okay.
I just want to add another point that a large portion of these arguments are relative to challenging the pre-1914 water rights, which are not at issue in this hearing, as you have ruled.
Right, yes, we are not considering those aspects. Okay, I'm going to sustain the objection about about the PowerPoint because it wasn't given in advance and the parties weren't given the privilege of reviewing it before the hearing. But you did provide exhibits and the parties have been aware of those. So the PowerPoint is not accepted. And at this point, you've indicated you want to take the second path and testify under oath. And so at this point, will you please stand, and you are, and raise your right hand? And you may do an opening statement, too.
Okay, yes.
Do you swear or affirm that the testimony you are about to give is the truth? If so, answer yes, I do.
Yes, I do.
Thank you.
My client, Executive Director of Klamath Riverkeeper, wanted to speak.
I just want to point out this may become the same issue with mine. And the notice of intent to appear, I mean, it had a couple check boxes, and I've spoken with staff about what the different pathways mean, but the way you're explaining the pathway is not clear from that. So I think it's stemming from that. My intent is still, as landowner, to provide evidence that can be in record and take the oath.
Mm-hmm. Okay.
Just
so
as
So do you want to take the oath?
when it is my turn to speak, I want to make sure that this same issue may apply.
Again, we have no written testimony by either one of these people.
I submitted everything. It's on that website.
You didn't submit any written testimony.
My letter is my testimony.
It wasn't submitted as such. It's submitted as an exhibit.
this-
I mean, all the other parties had to submit their testimony, and this is a summary of their testimony, not all of a sudden a whole set of testimony we don't know anything about.
Yes, and there is some confusion here. You know, this is not a board meeting. This
Right.
is an evidentiary hearing, and you
Yeah.
have to provide your written testimony ahead of time.
And-
Okay? There's rules.
I understand. And Barbara was on an email chain talking about who was going to get how much time to talk. There are different explanations of this process.
The hearing notice and the board's regulations and the applicable sections of the government code and the evidence code detail the process quite thoroughly. And, you know, we rely on counsel and folks who are represented by counsel to make themselves aware of these things.
Yeah, I think it would make a good sense to take a break at this time and for hearing team to confer on these issues. I appreciate you bringing up the procedural matters, and we'll take them under consideration at this time. How about just 10 minutes, Sam?
Vice Chair?
10 minutes, and we'll return at 11:35. Thank you. Thanks, everyone, for allowing us a little time to sort through some things. So I want to try to be as clear as we can. For Mr. Keibel, you can, you're offered the opportunity, as all parties are, to give an opening statement. And then when you're done with that, move over to the witness area to give any witness testimony that is subject, that is based on facts and is subject to cross-examination. And that'll apply to all the parties. And it's something we commonly do in water board hearings. So with that, you're free to make an opening statement.
Thank you very much.
I guess.
Let me
go
just
ahead.
quickly clarify that your, as is explained in the rules governing this proceeding, your testimony as a witness will be limited to the scope of your brief that we're accepting as your written testimony. So parties can, of course, object if they feel that you're exceeding that scope.
Okay. And thank you very much for your sort of thoughtful consideration of these issues. I realize that it was complex. I also just wanted to mention I did contact Water Board staff in advance about the PowerPoint and ask about that, and was advised at that point in time that if I brought 3 copies and on disk that I could use it. So I'm just letting you know that I made efforts to try and deal with that. Okay. So a core objective and mission of Klamath Riverkeeper is focused on the maintenance and restoration of salmon and steelhead fisheries in the Klamath as it relates to tribes, as it relates to commercial fishermen, as it relates to recreational fishermen. In the interest of time, I'm going to avoid covering what is largely already set forth in the written materials and really limit myself to clarifications that relate to some of the written testimony that was submitted by others in connection in the hearing, particularly as it relates to submissions by Marble Mountain Ranch. So I can't use the PowerPoint that I submitted? That's okay.
You can use it just like any person can use a pad of paper that
Okay.
has summary points, but we're not going to present it as, and I sustain the objection because
I can proceed without it. So there were sort of 5 main concerns that Klamath Riverkeeper was interested in covering for the purposes of this hearing. The first was to sort of highlight the issue of connectivity as it relates to Stanshaw Creek as a cold water refuge. The other issues relate to reasonable use, public trust, economic feasibility, and the relationship between reasonable use evaluations and how they relate to the lawfulness of permitted uses, which was set forth in the slide. Okay. So some of the written and oral testimony that was submitted, particularly on behalf of Marble Mountain Ranch, focused quite a bit on the extent to which Stanshaw Creek does or does not serve as spawning grounds for steelhead and for salmon. And the view of Klamath Riverkeeper is that this focus on Stanshaw Creek as a spawning ground is somewhat misplaced because the true value of Stanshaw Creek doesn't hinge simply on its role as a spawning ground. As the prosecution team and as NIMS has testified, for salmon and steelhead, they're cold water fisheries. And as cold water fisheries, when temperatures move into the high 50s, they begin to struggle. When they're above 60 degrees, they're usually dead. So the importance of Stanshaw Creek is primarily as a cold water refuge for salmon and steelhead that are migrating upstream and downstream on the Klamath River so that when temperatures get hot, they have a place that they can go to where they're safe. And the reason Stanshaw Creek is unique has to do with the fact that nearly the entire length, they have a very dense canopy of trees and a vegetation that keep water temperatures particularly cool in Stanshaw Creek, even when they're warmer. So we wanted to really highlight Klamath Riverkeeper, this issue of connectivity, and stay focused on that more so somewhat than the spawning issues. Second point relates to reasonable use, which obviously is within the scope of what we're looking at. A significant amount of testimony, both written and oral, was submitted related to the condition of the off-stream earthen ditch as it related to sediment and water quality. We heard quite a bit of testimony about that this morning. What Klamath Riverkeeper wanted to emphasize is that the condition of the off-stream earthen ditch, while important, is really not at the heart of the reasonable use issues that are before the hearing today. This is because reasonable use provisions, yes, they relate to off-stream conditions, transporting usage, so the ditch is within the scope of them, but reasonable use also relates to the in-stream impacts of diversions, and that the primary focus and concern related to the diversions on Stanshaw Creek by Marble Mountain Ranch really relates to the in-stream impacts, in particular these issues of connectivity and their impacts on steelhead and their impacts on salmon. There is a long line of decisions both by the Water Board and by the California courts that have focused in on these in-stream impacts of reasonable use. I'm just going to mention a couple of them. One, 1986, the Racanelli decision dealt with the issue of diversion's impact on salinity levels, and the California Court of Appeal upheld reliance on reasonable use to deal with the in-stream salinity impacts of diversion. 1980, California Supreme Court rules in Environmental Defense Fund versus East Bay Municipal Utility District about whether alternative points of diversion could reduce the impacts on salmon fisheries in the American River, a case that I think is particularly pertinent to our situation with Stanshaw Creek. And then finally, we've had a set of cases dealing with frost protection and direct frost protection diversions and their impacts on downstream users and their impacts on salmon fisheries. This is the 1976 Forney case and the 2014 Light case. Sites for this were provided in the PowerPoint, which I submitted hard copies of. I would be showing them right now if I could. So I wanted to highlight this because it seemed like some of the testimony and the evidence was really focusing in on the ditch and the off-stream impacts, and that in terms of understanding whether the Water Board has an appropriate basis to move forward with the curtailments that are under consideration, the diversion curtailments, there is a long and consistent line of cases that deal specifically just with in-stream impacts, and we wanted to highlight that. Third point relates to the public trust issues that are also mentioned in the notice of the hearing, so are therefore within the scope of it. Some of the written testimony submitted for this hearing suggested that the public trust or the public trust doctrine only applies to post-1914 appropriative water rights. Klamath Riverkeeper wanted to emphasize that it believes that statement is incorrect. The National Audubon case, the seminal sort of California Supreme Court case, the holding there was that all diversions from navigable waters or tributaries to navigable waters are subject to the public trust. Yes, the facts of that case dealt with a post-1914 appropriative water right, but there's nothing in the holding of that case that in any way limited it, and subsequent cases have borne that out. Most recently, 2014, we had a decision in Environmental Law Foundation versus State Water Board over the Scott River. This was a case that involved groundwater pumping, not even surface water diversions, groundwater pumping that was impacting flows in the Scott River and salmon and steelhead fisheries in the Scott River. The court did not hesitate to apply National Audubon and the public trust and find that even that groundwater pumping, which is not even a surface water right, was implicated. So we just wanted Klamath Riverkeeper to emphasize that that very narrow and restrictive reading of National Audubon, suggesting that the public trust only applies to post-1914 appropriative water rights, really has no foundation in law, is inconsistent with the cases that are out there. The next issue, I'll just keep moving forward, relates to the question of economic feasibility, which is obviously very, very important for all the parties concerned, including Marble Mountain. And so far, there's been considerable testimony and discussion over the costs associated with arranging for return flow. And that evidence and that testimony has been framed as if the costs are deemed excessive, or that really goes to whether it's economically feasible to move forward with some of the curtailments or recommendations in the NIMS report. what Klamath Riverkeeper wanted to emphasize is that that organization's view is that this focus on the costs associated with return flow is in fact somewhat misplaced, because the real issue in terms of the impacts on Marble Mountain Ranch is their need for a supply of electricity. They need a power source, and they currently rely on the current configuration for that power source. So as Klamath Riverkeeper views this, the appropriate inquiry regarding whether it's feasible economically is whether or not there are economically feasible alternative ways for Marble Mountain Ranch to maintain the necessary electricity supply. And there are a host of alternative arrangements out there that don't necessarily involve return flow at all. And we mentioned some of these in the written materials that we submitted, but one is to move the point of diversion further upstream so that the flows for generating the hydropower return to the watershed naturally. You wouldn't need to arrange return flow if you change the point of diversion. Another alternative is to have a more updated, efficient micro hydropower system that would require less water to begin with, rather than dealing with the sort of older, antiquated model that they have. A third alternative is that many people in this area, in the Klamath Basin, don't rely on hydro at all. They rely on a combination of diesel generation or some integrated diesel solar generation, and the costs that appear to be associated with those alternatives appear to be well below the costs associated with arranging for return flow. Now, I'm not going to be an expert that can testify as to those costs, but our point is simply that as the Water Board and the hearing officer is thinking about the question of economic feasibility, Marble Mountain Ranch is really trying to focus on the return flow issue. We think it needs to be broader, and it needs to look at whether there are alternatives. And when you look at the reasonable use and public trust state water board decisions and cases that are out there, they've all focused on alternatives, whether there is an alternative. So you think of, there's this case, and I have a cite to it in my PowerPoint, but since I can't put it up, this 1935 Tulare irrigation case, the gopher drowning case. The court said you don't need to drown your fields, flood your fields to manage gophers and rabbits and other pests, because there are other alternatives. Erickson case, about 1971 case, it's also in my materials, so I did cite to it, deals with loss of water in an earthen canal to evaporation and transpiration. The court, in finding that unreasonable, said you could put it in a pipe or you could line it. And with the frost diversion cases, which I already mentioned, the court essentially upheld that regulation of direct diversions, because they said, why don't you just get off-stream ponds so you're not diverting? Why don't you consider that before moving to direct diversions? So what Klamath Riverkeeper wanted to emphasize is that in looking at reasonable use, the issue of available alternatives to meet the needs of the property owner and the water rights holder has always been a part of that analysis. So what we're suggesting, looking at alternative sources of energy supply for electricity, is very much in line with, we're not expanding reasonable use at all. In terms of public trust, the State Water Board issued a sort of a landmark decision in 1994, 1631, over the Mono Lake cases. One of the things that they looked at is they found that to implement what they were considering, there would be an 18% reduction for the Los Angeles Department of Water and Power. The State Water Board looked at that and said, you know what, between additional water recycling, water efficiency, better groundwater management, we're convinced that you can find a way to make up that 18%. And on that basis, they sort of upheld the restriction on diversions. I think that situation with Decision 1631 is highly analogous to what we're dealing with Marble Mountain Ranch and Stanshaw Creek, which is that it's not necessarily the place of the Water Board to order any landowner what electrical power system they have. But I do think it's within the scope of the Water Board to say, if we're trying to consider what level of curtailments, are there feasible alternatives to electricity that mean that the curtailments that you want to do to protect the fish are feasible? I think Decision 1631 is very much on point. And one last, and then I'll sit down and hear what questions you have. In the pre-hearing ruling, there was an objection that was made to certain written testimony related to the pre-1914 appropriative water right, and the vice chair, the hearing officer, agreed, and I think correctly, that for purposes of this hearing, a finding could be made that the diversions are unreasonable because, in particular, of their impacts on in-stream impacts on the fisheries, without making any finding whatsoever as to whether or not the uses of the water are consistent with the pre-1914 right. And I believe that is absolutely correct. And I think that ruling was in response to evidence that Klamath Riverkeeper had submitted, suggesting that the 1867 notice only listed mining and agriculture and didn't include off-stream hydro. But what Klamath Riverkeeper just wanted to note for the record is the fact that for purposes of this hearing, an unreasonableness finding could be made without getting into the question of the lawfulness of the uses. I think that is absolutely correct. The question of whether or not it's lawful does bear on the question of unreasonableness, and I wanted to just explain as a closing point why. And it relates specifically to a case called Orchard v. White, which I have on my PowerPoint slide, and I'm happy to give a cite to. This is a California Court of Appeal case, 1950. Very traditional reasonable use fact pattern. Two farmers irrigating their lands using pumped groundwater. The groundwater table's going down, and one overlying farmer sues another farmer saying, I think your pumping is excessive and is unreasonable. But there was a wrinkle in this case. The wrinkle was that the defendant, one of the farmers, had a pipeline installed and was taking the water off of the overlying properties and using it on non-overlying parcels. So in addressing the reasonable use question, and I'm happy to give you the site for Orchard v. White if you want it, the court first looked at whether the use of the pumped groundwater was lawful on the non-overlying parcels. And the court actually said, in terms of how it framed its reasonable use analysis, and I'll quote from the case, and this is all in the PowerPoint, quote, an owner or any other person having a legal right to surface or groundwater may take only such amounts as he reasonably needs. It's that focus on the legal right that in Orchard v. White, there's an example of the court not actually being, the court determining that it couldn't undertake reasonable use analysis as to the amount and quantity of the pumping without first looking at whether part of the use was in fact unlawful because it wasn't on overline. I believe, and Klamath Riverkeeper believes, that that holding in Orchard v. White is very much on point for our hearing today. Because we have a situation where some of the diversions for Marble Mountain Ranch are being used, a significant portion, most of them, for off-stream hydropower generation under a pre-1914 appropriative water right. But that pre-1914 appropriative water right doesn't list off-stream hydro use. It's limited to mining. So I'll leave it up to the hearing officer to decide how to proceed, but the point we wanted to make is it seemed that in some of the written submissions there was this view that determinations of unreasonable use or wasteful use under Section 100 of the Water Code are somehow completely unrelated to issues of lawfulness. And how we would frame it is it's absolutely possible to make an unreasonableness determination without getting into this at all. We agree with that. But they also are related. They are related, and I think if you take a look at the Orchard v. White decision, you'll sort of see an example of how the reasonable use inquiry and the evaluation of whether or not it's a permitted use in certain situations, and I think it's the case in this one, have a connection. So with that, I'm happy to take a chair there and answer questions. Once again, just to clarify, I am not here as an expert for the solar industry or the diesel generator industry, so if there are questions relating to those matters, those exhibits, I'm not going to be in a position to answer them.
Okay.
Thank you.
All right, thank you, Mr. Keibel.
Should I sit?
Sure, thank you. Maybe, or can you grab your name tag? So you're on video and audio.
Yes.
Thank you.
Thank you very much.
Okay, so that concludes the opening statement. And Klamath River Keeper is available for cross-examination. First, anything you would call direct testimony at this point? Yeah, I didn't think so. So first offer for questioning is Division of Water Rights Prosecution Team. Do you have any questions? Second, Marble Mountain Ranch. Do you have any questions for Mr. Keibel?
I'll only be here a minute. I don't have any questions. I'm going to go ahead and make a motion and object to this as testimony. This is all legal argument, and no evidence was submitted, and request that all exhibits referenced in his submittal, Klamath River Keeper's submittal, be stricken from the record.
May I respond to just one of those points about the exhibits?
Go ahead.
After the written testimony was submitted, there were objections filed by Marble Mountain Ranch to those same exhibits on hearsay grounds, which were overruled by the hearing officer. So it feels like this objection actually, which appears to be sort of a hearsay objection, was already submitted and ruled upon.
Yeah, and I thought I was trying to be clear, counsel was clear that you can object to anything that you believe is outside of the written products that were submitted and were accepted by me in this hearing.
Well, the entire statement or testimony, whatever you're going to call it, was legal argument. There's no testimony, there's no evidence referencing those exhibits. There's nothing about those exhibits. They've been submitted without any testimony associated with them. So not only are they hearsay, but they're not authenticated. There's nothing, no testimony about them other than they're just being submitted.
That's okay.
Yeah. Amongst the exhibits that we submitted was a brief prepared by me that outlined a lot of these legal issues, and most of the issues that I spoke to today in my remarks related to that exhibit, which was already submitted.
That's not evidence, that's legal argument, right? So if you want to submit a brief, but you
It was an exhibit. You can characterize it how you want.
Yeah, and I'm concerned here, we're dealing with semantics. You know, for the purposes of the water board hearings, we ruled on this issue of what had been submitted as exhibits on October 31st. We overruled your objection in that case. And so I'm only interested if you can point out to specifics within what his testimony was today that are not included in the written testimony that he submitted and we accepted into the record.
What I'm referencing are exhibits 2, 3, 4, 5, and 6 of the Klamath River Keepers. And I'll just re-emphasize my objection is failure to authenticate, failure to even rely upon it, indicated they can't answer any of the questions regarding solar estimates that are submitted. So there's nobody to cross-examine with regard to any of that exhibit. In fact, there's no testimony referencing any of those exhibits, just a legal argument.
Okay,
So
overruled.
That's fine.
Thank you. Okay, we're welcome to ask any questions, but if you don't want to, that's fine. Next, National Marine Fisheries Service. Department of Fish and Wildlife. Karuk Tribe. Old Man River Trust. California Sport Fishing Protection Alliance. Pacific Coast Federation of Fishermen's Associations? No? Okay, and so, yeah, you didn't offer any direct, so I don't know about redirect. And I'm looking at the clock. Let's see. I would just request Klamath Riverkeeper offer any exhibits into evidence.
Other than the PowerPoint, but I'm a little confused about its status. The PowerPoint did provide some citations to cases that I discussed, and I feel for the benefit of Marble Mountains Council, in case they want to address it in their closing post-hearing brief, that I would like that to be made available if it can.
So your PowerPoint has not been accepted. We talked about that. I mean, we have the 3 copies that you handed staff. None of us have looked at them. I was going to request that when you're done, you meet one of us over there, and we'll give them back to you. And then, you know, whatever you want to do with your 3 copies is your business. But we're
Fair
not
enough.
accepting them. We haven't looked at them. They're
Okay.
We'll get them back to you.
One point of clarification, if, as I know it's common to do sort of a post-hearing closing brief sometimes, if I wanted to include that PowerPoint just for the benefit of the parties, would that be permissible? If the answer is no, that's fine, but I'm really doing this so that everyone has the benefit of it. I don't know what your view on that would be.
We're going to accept closing briefs.
Okay, so I'll make it available then. Okay, thank you very much.
So at this time, as we said at the beginning of the proceeding, wait, you guys want to confer? All right, just as a point of order, we've accepted the exhibits as moved by Klamath Riverkeeper. And I want to do a time check. So if we're at a point where we're moving on in the proceeding to the Karuk tribe portion of the proceeding, I was going to suggest that we take a break unless you have a schedule constraint. Yes.
There's no constraint that requires we don't take a break here now.
Okay.
Just for clarification, I didn't do a great job listening apparently this morning. What's the proceeding? Are you asking, I'm expecting that I'm just presenting the testimony of Mr. Hillman.
No, as with all of the parties, you're to make your opening statement.
Okay.
And direct testimony of Leif Hillman, followed by any cross-examination.
And then I'll save my other witnesses for when I would have shown up in the hearing had it not gone out of order.
That's how we have it set up, yes.
Okay, thank you.
Okay, well, I think it'd be a great idea to take a lunch break. So it's 12:10, let's resume the proceeding at 1:10. Thank you.